society structures, fellow South Africans who are following deliberations of this committee from time to time. We are, of course, meeting here today in the main to deal with items that talk to the committee making decisions on certain matters, including legal advice on some of those. But as we do that, we would want to just deal with the formalities quickly. The first would be just the rules as a way of reminder to all participants, in particular members, that the rules of the National Assembly on virtual platforms would apply to our meetings. So a reminder, therefore, that at all times, please ensure that your mic is muted, as well as your video camera is switched off until you are recognized by the chairperson. In that case, once the chair recognizes you, you'll then unmute your mic, as well as switch on your video camera so that those that have to follow the discussions are able to follow the speakers that are on the platform. This would also apply, honorable members, in situations where you may lose connection and have to reconnect to the platform. That ensure at all times that you do that with your mic muted, video camera switched off, as mics are sensitive and could pick up background sounds that could disturb a speaker that may be on the platform at the time. As it relates to point of orders, whilst the rules make provisions for point of orders, members are also reminded that in terms of the rules, you would not unmute your mic without being recognized by the chairperson. Only the time the chairperson would have recognized you, that you'd raise your point of order on which the chairperson can rule upon in terms of the rules. Of course, we are guided not to have unnecessary point of orders that could collapse the meeting on this platform. Having said all that, honorable members, this should then help us to run our meetings smoothly as it is usually the case. I will therefore, without further waste of time, check if there are apologies received from members in particular for the absence, if there are any, for purposes of record. Committee support.
Morning, Chairperson. Ms. Kubeka indicated that she will attend. She'll just be a little late, Chair, because she's on a flight. Dr. Pasopo indicated that he would leave at 10 this morning. And Ms. Bodlani did indicate that she'll be late to the meeting, but she is on the site, Chair. So thank you very much.
Thank you, Ajra. I take it that honorable members will take note of those. Of course, would be able to cover probably a lot of ground by that time. So having noted those apologies that have been received from members, I take it that they are great. Can we then get to the items on the agenda? Yes, honorable members, as you would see on the items on the agenda, would be taking two legal advices from the legal advisors of Parliament on the ICASA PMS and on the MDDA matter, which we needed to get guidance on before we proceed with our task of doing oversight as agreed by the committee. We have agreed to put this earlier as there was an indication that the same services may be needed by the other committees. Just before I do that, I'm sure committee support will indicate whether they are on the platform and who's on the platform. But just for purposes of correctness, Honorable Bodlani has just posted, and it's agreed that necessarily she registered an earlier departure, not a late arrival. So we'll just correct that so that it reflects correctly, so that at the time she leaves, it will be because it was part of those that were approved to be leaving earlier instead of what has been reported earlier on. Keep that, honorable members. Can I then, like I said, just check if Hajira, like I said, I have gadget issues on the side. If we can have introduction of who's here from the legal, and
Yes.
then I can be able to give them the opportunity to speak to the committee. We'll take the two together and clarity is taken later.
Chairperson, we have Ms. Pumaleli Ngema here from the Legal Services section, and then also Mr. Andili Titania. Thank you, Chair.
Okay. I hope they will be able to hear. I did hear you said Mr. Dejan is here.
Yes,
I
Chair.
didn't hear
And
the other.
Pumalele, she's on the side, Chair. There's no surname.
Okay, I'm sure they'll be able to deal with that properly. But I did hear the other. Can I then, I'm sure you'd have arranged Mr. Tejana on how you are going to approach the two, but we are asking that we do both. And then only if there are clarities, ask clarities thereafter. Thank you. You are welcome. You can go to the podium. Thank you.
Well, good morning, Chairperson, honorable members. I'm looking at the agenda, Chair, and my colleague is supposed to start. Pumalele, are you on the platform? Yeah, she's on the platform. But, for some reason, I can't hear any sound.
Greetings, honorable members, and greetings to my colleague and everyone on the platform. Yes, I am on the platform. I was thinking the chairperson indicated that you may start and maybe explain the position about the two opinions. Mine is fairly simple, and I must indicate to the members. I hope I'm audible, Chairperson.
Yes, you are. You are audible.
Thank you. The name is Pumalele Ngema.
Ngema, not Ngema.
Ngema, yes, Chairperson Ngema, Ngema. I am the legal advisor who was asked to assist in respect of just considering the performance management plan that was sent for concurrence to the committee. So mine, Chairperson, does not even have an opinion because I quickly looked at this and assisted the support staff in this regard and just pointed out my views and matters that perhaps the committee would when they deal and deliberate with this matter may just consider, Chairperson. So maybe, Chairperson, if you may clarify, I am here. If I can go ahead or Mr. Tetyane can start with his opinion, I am available either way.
No, Mr. Ngema, because you're already on the platform and the indication from Mr. Tetyane was that you will start there because it's number one. Speak to the PMS issue, and then you'll then follow. That's how we understood it. So you can proceed.
Thank you so much, Chairperson. And like I said, mine was basically to assist and minor issues that I noted, and I did not prepare any written legal opinion, but I made my comments tracked in the document that was shared with me. So, Chairperson, in broadly, what I pointed out first pertains to the issue of the separation of powers, when the Act as well as the plan that has been sent to the members is dealing with the remuneration for the panel that will be appointed in order to deal with the performance assessment of the council as well as the councillors themselves. I thought maybe there, Chairperson, the members under item 12 may consider that whether the involvement of Parliament in setting that remuneration, or specifically the National Assembly through its committee, will be safe, as well as if the committee considers appropriate, they may just make recommendations in respect of that part to say that rather the consultation, and it must be an after consultation, done with the Department of Treasury so that we can ensure consistency in line with the consultation of the committee that determines the remuneration of the independent constitutional institutions. And that was my suggestion, that perhaps the committee may look into that and see if they cannot paraphrase or couch a recommendation in that light. And that is in respect of the remuneration for the panel. And furthermore, Chairperson, my contribution was in relation to Section 8 as well as Section 6A of the ICASA Act and what is expected of the committee. But obviously, as the subsidiary of the House, the National Assembly, is that when the report of the panel is done, the committee is supposed to consider it, but we do not have further details, and perhaps institutional memory may assist in finding the intention as to what was it that at the time the Act was promulgated was intended, what would be the details of considering the report of the panel when the assessment is done. And again, in that, the issues of the separation of powers arise when we move in instances where a dispute may arise in respect of what has been given as the performance assessment of a specific councillor. So in respect of attempting to deal with the dispute resolution, should that arise, and the review, once the committee receives the report of the panel, what can be done, and is that process practically implementable, and ensuring that the principles of natural justice will be correctly and appropriately implemented and followed in that regard. But that one, Chairperson, as I noted in my comments, is basically a matter for consideration into looking at whether the provisions are clear enough, and if not, because it's provisions of an act, it's just a matter for consideration when the committee speaks to the department as well as considers effecting amendments to the act in this regard. And what I said in respect of Section 8, Chairperson, was that rather than make a specific reference to 8.1G as the only misconduct ground, rather be safe where that is referred to in the PMS, in the performance management plan, that we just refer generally to Section 8 in its entirety without being specific to only one single provision. Basically, then, Chairperson, those three were the issues that are raised for consideration and deliberation by the committee, but not necessarily in this instance to indicate that there is anything wrong or untoward with the performance plan as sent. It was just matters that the committee may consider and deliberate and make a recommendation upon if that is necessary. Chairperson, I'm just going to quickly go down my document to see if I've left anything, but I believe that is generally the concerns that I raised. Chairperson, I think without taking too much of the time, I also made reference to point 13.6 of the plan. I noted that section 8.2 expressly and clearly articulate the consequences where a non-performance or unsatisfactory performance is picked up and confirmed by the evaluation panel. A recommendation to suggest that 13.7 be inserted to make reference to section 8.2 of the Act. I think it's the same one, Chairperson, that I already pointed out that let's make reference to the entire section 8 because it's safer that way, and we ensure that all the provisions are covered. And then I think I just made one or two inserted additions. That is all, Chairperson. Thank you so much.
Thank you, Ms. Gama. Will then take Mr. Deja.
Morning, Honorable Chairperson again, and morning to honorable members and colleagues. Chair, you will recall that the reason why we are here is because of the committee's wish, or rather the recommendation of the MDDA board to close the meeting, the oversight meeting, which the committee intends, to have with the MDDA. Now, Chair, what we want to point you to, Chair, is that, as you know, the rules of Parliament, Chair, allow for instances where meetings of committees are closed. But the point that we want to foreshadow, Chair, is that there are basically four rights, Chair, which are implicated here. The first right is the right of access to information, which is section 32 of the Constitution. Now, the second right, Chair, is the right of freedom of expression as it relates to the media, which is section 16(1)(a) and (b). And then potentially, Chair, the third one relates to section 14(d) of the Constitution, which is the right to privacy. Now, the fourth one, Chair, potentially as well, relates to section 10 of the Constitution, which is the right to human dignity. Now, Chair, as you would know, accountability is one of the founding values of our Constitution. And section 1D adopts a multi-party system of democratic government to ensure accountability, responsiveness, and openness. Section 411C provides that all spheres of government and all organs of state within each sphere must provide effective, transparent, accountable, and coherent government. What we're saying, Chair, is that the default position, and we take cue from section 59 of the Constitution, where it says that public access to involvement in National Assembly. The National Assembly must facilitate public involvement in the legislative and other processes of the Assembly and its committees, and conduct its business in an open manner, and hold its sittings and those of its committees in public, but reasonable measures may be taken. Now, all we're saying, Chair, is that the problem that we had, as legal services, Chair, is the fact that we didn't have sight of this particular information, because your brief merely says, Chair, that this is sensitive or personal information which relates to the affected employee. So that's why, Chair, we then said that if you look at the rules, particularly Rule 184(2), it says that due consideration, Chair, must be given. So in other words, the committee must have applied themselves to the information itself. But as Chair, as you know, even in terms of the Promotion of Access to Information Act, access to information may be refused if its disclosure could reasonably be expected to endanger the safety of an individual. And it may be refused, for instance, if its disclosure would be likely to impair the security of a building, a computer system, and so on and so on. So all we're saying that, Chair, is that the reason why we said at the end that we cannot give a definitive view is precisely because of the fact that we didn't have sight of the information itself. We can't make a determination whether, because we always find ourselves, Chair, in this space where people say we want to close a meeting because there's private information that is going to be dealt with. But our view, Chair, is always that, of course, the committee must be given that information, the committee must look at it, and the committee must then make a determination as to whether it then limits the right to access to information, or for that matter, the right to freedom of expression as it relates to the media. And of course, Chair, I mean, if you look at Section 36(1) of the Constitution, there's a two-stage inquiry. The first inquiry, of course, is the question of whether a certain right has been infringed, and of course, if the answer is yes, and then the second stage is that we move to the limitation analysis. But Chair, look, if I may frame broadly, our issue was just that was just the fact that we could not apply ourselves to your so-called sensitive or personal information, Chair. So if we can have sight of that, then of course we'll be able to say, okay, we think that based on the criteria I've just described, some of these rights warrants limiting, and therefore for that reason, the committee must close its session. I'll end it there, Chair. That's the crux of our opinion. Thanks, Chair.
Thank you, Mr. Tejana. I hope I'm still now audible. I've tried to change the gadget again. I'm now going to invite members who may want to clarities or make comments, so that once that is done, we'll be able to release you and take a position on how we need to move forward on those matters. I saw Honorable Kola Barnett. Not sure whether I wanted to speak on that first one, but you can do both
Thank you, Chair.
at the same time. Thank you.
Yes, I have two questions. The first on the initial presentation by Ms. Ngema, or Advocate Ngema, I'm not sure what title to use for her. I would ask that we receive a single document from her detailing her proposed amendments. It's far too easy to flash through in a meeting like this and miss one of her proposals without us having a standing document to work from. So I would request that that is done and given to the committee. And then moving on to the second legal opinion, I must say I agree with it. There's insufficient information, but as a matter of principle, I'm totally against closed meetings. In this instance, it seems the MDDA wishes us to close a meeting because they wish to discuss some individual's private matters. Now, private individual issues should surely be sorted out by the HR department within their own division. I'm most uncomfortable with them wanting to come to us with information. If it's a matter of laying some sort of internal charges against a person, they must do that. What is it they're expecting us to do? To judge an issue that they're going to give their opinion on? I think it's right far outside the mandate of this committee to involve themselves in a matter like that. We can't shut down the public participation process at the behest of one of the entities we oversee. So I'm very uncomfortable with this proposal, and I agree with the legal opinion. Until we know what on earth it's about, we can't take a decision like that. Thank you.
May I just get, I think there's a response from Ms. Ngema, which then confirms that they would comply to that, that of circulating as per the request of Honorable Member Kolaband. I think the other part, it's really to strengthen the point that indeed would need that. But from the committee support side, Mr. Dejan, we asked for the same, that it is the request made by the board and the board must furnish us that information. And this is how we dealt with the SABC request before, as well as the SAPO request before. So at this point in time, the point raised was more about private information of employees, and that this may then be an issue that borders on the POPI Act and so on. So I had to receive that part. But I think we have the basis in any way to make a call also when we receive that part with the explanation given to all members. So we thought also it was important to do so because we also have members that may have not participated in the other applications we had to deal with. And therefore getting it from yourselves would be quite helpful as to just a ruling made by a chair of the meeting on understanding of rules and also the experience of how the other ones would have been treated. So I just thought it's important to clear that part. Honorable Bodlani.
Thank you so much, Chairperson. Chairperson, one of the issues that I believed that we were going to request the legal opinion on is how the committee is going to handle matters that are deemed to be sub judice when we do meet with the board. I don't think the legal opinion covered that, because the question I asked in the previous meeting was, where do our powers start and begin when we are going to be asking questions, and we don't want to waste a day by being told everything is sub judice. So for me, it's just the powers of the committee. Thanks, Chair.
Thank you, Honorable Boladi. Any other member would want to ask a question? Okay, no. If there are comments to be made at this point, I would allow you, Ms. Gema and Mr. Dejana, to make your comments before we release you, and then we take a way forward ourselves on the two matters. Thank you.
Sorry, Chairperson, may I also check if I can be excused before interrupting Mr. Dejana, as I need to be in two other committees?
Yes, that's the reason we asked you to start. We did indicate that you are also expected to give similar services to other committees, and we'll release you.
Thank
so
you,
if there's no comment at this point, that's fine. Mr. Dejana, you do want to comment at this point?
Yes, Chair, no, that's fine. Regarding the point that Honorable Bodlani has just said, Chair, all we want to say is that we are always confronted with this question, Chair, where people, because they are running away from accountability, they then raise the sub judice rule. And our attitude, Chair, is always simple. A portfolio committee chair has a wide discretion to determine its own procedure and ultimately to compile its own report, even if it means it must then report to the National Assembly. But the point we want to make sure is simple, is that the legislature, Chair, which is Parliament, and the courts, Chair, occupy a similar plane, Chair, in terms of importance as part of the three branches of the state. It's just that, Chair, these two institutions have different mandates. It doesn't mean, Chair, that when a matter, for instance, is serving before a court of law, Parliament's hands are tied. In other words, Parliament cannot do anything up until the court concludes or finishes this business. Parliament Chair, this is an activist Parliament. One of the values of our Constitution, Chair, is responsiveness. And of course, we cannot hold people accountable, Chair, without having the necessary information. The subjudicate rule, Chair, merely speaks to whether we will then look at the merits and interrogate them as a committee of Parliament. But it does not say, it does not say that there's nothing we can do. If you look at the rules, particularly Rule 227 of the National Assembly, Chair. Rule 2271B says that the portfolio committee must maintain oversight of the exercise within its portfolio of national executive authority, including the elimination of legislation, any executive organ of state falling within its portfolio, any constitutional institution falling within its portfolio, and any other body or institution in respect of which oversight was assigned to it. Now, 2271 goes on to say that a portfolio committee may monitor, investigate, inquire into, make recommendations concerning any such executive organ of state, constitutional institution, or other body or institution, including the legislative program, budget, rationalization, restructuring, functioning, organization, structure, staff, and policies of such organ of state, institution, or other body or institution. So, Chair, I think the point I'm making, Chair, is that it's incorrect, Chair, for people to say that, no, this thing is before court and therefore Parliament's hands are tied. Parliament cannot do its oversight function. Parliament, Chair, is enjoined, by the Constitution to play its role. Parliament and the Judiciary, Chair, are institutions who possess equal standing in respect of their respective mandates. So, of course, courts must stick to their lane, Parliament must stick to its lane, but it doesn't mean that when a matter is before court, that sterilizes Parliament in terms of its oversight obligations. I'll end it there, Chair. Thanks.
Thank you, Mr. Tejan. I take it, Honorable Bodlani, your question has been adequately responded to. And it asks the committee.
Follow up, Chairperson?
Yes, you can proceed.
Chairperson, I think this then puts a spanner in the works, because if there is still going to be an issue of whether the meeting is going to be closed or not, and then there's issues of sub judice or not sub judice, then it means we should then go back to the legal office and request opinion on that, because what the advocate is explaining is clear. But in line with the first argument, the first part of the conversation that the committee was having, maybe once we have those two and we have it in writing that we provide the board with that written report, then we have covered ourselves as a committee and we know that the powers that we go into that meeting with. Thanks, Chair.
Thank you, Honorable Bodlani. Is there a member who wanted to speak that I may be leaving behind? Because there was some background sound. If not, I think we should be able to release also Mr. Tejan to go and assist the other committees. I think it's given us the basis to have a way forward. So we really want to thank you, Mr. Tejan. Of course, you will take into account that we would need this combined into just one, the response you've given and the initial response which was stipulated, so that we will use this as the basis as we take the matter forward. It helps because indeed it's not the committee that has asked to have it in a closed session, but also it's not the committee that doesn't want to do oversight on those matters, but these were matters raised by the board itself. And I'm sure the department and the ministry will take that kindly as we get to do the work Parliament is expected to do. So thank you for presenting yourself to the committee to further clarify what you've put together. Thanks.
Thank you so much, Honorable Chairperson and honorable members. Thank you.
Thank you. Yes, we can release you. Honorable members, I think just on the two matters that have been raised with the clarities that you asked for, I just want to check if you'd agree that indeed would not spend time on the two items except to get some sense of way forward. And this is what I want to put as a guide to the meeting. That on the first one, the understanding is that the framework itself, there's no problem, except to strengthen certain points, especially where it puts limitation, that we have a better scope, like instead of selecting a particular section, a subsection in that section of the Act, rather take it as a whole, so as all misconducts, I'm making that as an example that has been given, that we get those strengthened, of which Ms. Ngema would have committed that will then be submitted in writing, so that at the end we are able to get back to Parliament and report that we agree to the performance framework that has been put by the department, presented to this committee, and that then they can proceed to ensure that the councillors in ICASA sign those performance agreements, and that performance management system is now agreed will then apply. So which would mean that what will come before us will just be a version that makes those amendments as our final response as Parliament on that PMS for ICASA councillors. So this is important because we have also just gone to the House to approve that the minister appoints the other 4 new councillors in ICASA, will be embarking in no time to another filling of a vacancy that has occurred at ICASA, so that they are able to be measured in their performance both collectively and individually. That's the first point. So I would want you to comment on that before we move to the next point about the MDDA itself. Honorable Kola Barnett, you are recognized.
Thank you, Chair. From our perspective, I wonder if it would be, if we should schedule a request for a quarterly report from them to keep us up to speed. It's no good us finding out at the end of a year or end of a term that in fact a member has not been performing, not been attending, not been contributing. So as a means to strengthen the oversight, if we could ask for quarterly reports from them, I think that would have us fulfilling that role. Thank you very much.
Any other member want to contribute? Okay. I take it that anyway your input, Honorable Kolabanat, is still raising a hand, or is it legacy one? Okay.
Apologies.
I take it that there is no disagreement on the summary, but what is being added is that in the quarterly reports, which we usually get as the committee, that we also get a sense on the performance of members of the council, so that, like you are already saying, Honorable Kola Barnett, that we don't get it very late, that others are not functional in the process. So as part of the quarterly reports, would also have performance of members, but their summary is agreed upon, so that when those changes are made, it will be for us to note and then respond to the National Assembly, which then would mean the minister receiving it and they can proceed with signing of performance contracts. So that will be on that one. On the part about the MDDA, I think there's the clarity is now there. We would have asked the MDDA to forward us with compelling reasons why that would have to be a closed session, or whether it will be part that is closed, or the whole session, which is a matter that is subject to approval still when we make an application to the House Chairperson, because all those sections of the Constitution that have been quoted get to be satisfied before such an approval is made. And therefore, honorable members, I think as a way forward, we should still apply to have that oversight going on. We would have that legal opinion also attached to it. So if we do not receive anything from the MDDA, you would make the assumption that they have reconsidered their position after assessment, that from a point of accountability and transparency, there would be nothing to hide. May I then take, as I said again, members who would want to comment on that as to whether that should be the way forward for the committee to proceed with that.
Agreed, Chair.
Chair.
Agreed.
Right. So that having been agreed to.
Yeah, we agree, Chair.
Thank you, Honorable Mlala. That having been agreed to, it means we'll then proceed to put our application post this meeting so that we can get suitable dates in that regard. So that takes care of 1 and 2. If we can just get agenda flighted again, so that we get to the next item. Am I still on the platform?
Apologies, Chair.
Yes,
on my side.
Okay. Just want to be sure all the time, because get to be kicked out even by the host sometimes mistakenly. So we now have to consider what has been received as written submissions by the committee on the Postbank Bill. I'm sure that would be a matter for the content advisors to update the committee, and for the committee to be able to take a way forward in this regard. Between Dr. Midupi and Mr. Malika.
Good morning, Honorable Chair, and good morning to the honorable members. Indeed, we have received a number of written submissions, Chair, even though they're at the very, very minimal. So far, only 3 written submissions on the bill have been submitted, and that was from COSATU. The other one was from the Financial Sector Conduct Authority, FSCA, and the last one was from the Banking Ombudsman. Suffice it to say that, Chair, that after the first request for written submissions, and we did not receive as much except for COSATU in the first round, we then went further and we approached the individual interest groups within the sector, and one would need to indicate that those that were approached were your PASA, which was Payment Association of South Africa. We also approached the National Stokvel Association of South Africa, We approached FEDUSA. We approached BASA, Banking Association of South Africa, Vet School of Law, Ombudsman Banking Services, Financial Sector Conduct Authority, Right to Know campaign. We also approached the BRICS Bank, Competition Commission of South Africa, and the National Credit Regulator. And out of that, those numbers, the only additional written submissions after COSATU had initially submitted, as indicated, was only from FSCA, and the other one was from the Banking Ombudsman. That's how far the matter on the bill goes. And Chair, if you may, Chair, if there's anything from Mr. Malika to add on that, but that's how far we've gone in as far as, processing the written submissions, is concerned. Thank you very much, Chair.
Through you, Honorable Chair, Honorable Members, I just wanted, I thought Dr. Midupi would touch on the part that there's only 2 of those 3 that have requested to appear before the committee. Thank you.
Thank you, Dr. Midupi and Mr. Malika. I see that members would want to engage, but I just thought in just concretizing the point. Firstly, is that we would remember that we have received this report as the committee where we had on COSATU, and we took it upon ourselves to indicate that we would want to still open up, which then changed our program to open up and invite specifically those sectors or organizations that play a role in that space to receive comments, but also check that as this was coming from Cabinet, what are those submissions that would have been made in the public participation that the department would have run with. And there was nothing to get from that process. But we now have 2 more, with one also asking to join that of COSATU to appear before the committee. So I thought it's important to go back to this point, that it was the initiative of the committee to still further consult to get comments after the first closing date. Honorable Kolobant.
Thank you, Chair. I really don't think this is good enough. I mean, the proposal of actually creating an entire bank is a massive one. It's massive. And unfortunately, there is, there are the outrages of the whole VBS issue and the looting of funds there that are still very fresh in the minds of South Africans. And I really think it is this committee's job to ensure we get inputs from these other entities, even if one targets a specific individual at each of these entities and writes as the committee personally to that person. I'm not sure how the approaches were done by this committee, but I really think we need to chase up these inputs. We really to look at a proposal like this with well, it's really only 2 inputs. The one basically says they don't really have an input to make, is really not good enough and would never pass the public participation criteria. Thank you.
Any other member who would want to comment? Another member? This is about the State Bank. Honorable Pambo.
Chair, just to follow on with what has been said now by the colleague, maybe what we need to know is how were these institutions approached? Were they written letters? Were they called? And maybe the fault may be with us in approaching them. So let's just try find a way to make sure that we get as much of inputs as we can, because as Kolapanada just said, it's real. It's not something that we can just gloss over and take decisions from there. We really need to get as many people as possible to come in and say something. Thanks, Chair.
Thank you, Honorable Pambo. Any other member would want to speak? Before I give to content advisors to just indicate first and second approach.
Yeah, thank you. Hello.
Yes, Honorable Mlala can proceed.
Yeah, no, I think the point raised by my colleagues is valid, but the challenge I have is, are we enforcing that people must comment even if they are given an opportunity, unless if we say we have not broadened the scope of public comment to an extent that everybody had an opportunity to comment, because we might as well get stuck with waiting for comments that are not coming. So maybe if I could be clarified in that regard, maybe there's a point I miss, because in my view, that should be the approach. If everybody has been given an opportunity, we can't really force people to comment. But if not, then I agree with my colleagues there. Thanks, Chair.
Thank you, Honorable Mlala. May I then give to content advisors to just indicate process followed. And after that, I think we should have a way forward.
Thank you, Honorable Chair. I think it suffices to say, Chair, that indeed each and every one of those interest groups were identified, and we also made sure that there were, written invitation letters that were sent to each one of them, being very specific in terms of, what the committee is requesting. That's how far, the process of invitation has gone. And having done all that, still, Chair, we did not receive any response, to the rest of the groups, except for, as indicated, the Banking Ombudsman and the FSCA. But the rest of the stakeholders were written to, with specific letters addressed to each one of them. And having done all that, there was still no responses coming from those individuals. Thank you very much, Chair.
That's a response, honorable members. Not sure if there's a follow-up before we get to on the way forward. If there is no follow-up question having been clarified, I think then we would have to look at a way forward. I think there are maybe two steps we can take, but I want to still repeat first the point I made. The bill emanates out of a cabinet process, which then also had a public participation. And as I said, we couldn't get the substantial comments we needed from the department process when we opened up the committee process. The committee process was a public process based also on advertisements and all that to call the general population to respond to the call on the changes that need to be made on the Postbank Act to allow the Postbank to be a bank like the other banks would perform its functions, including its board meeting the requirements of what the Reserve Bank would expect from a bank. Then you ask for comments in public. In that first process of public participation, which was advertisement and all that, there was a response from COSATU, which also requested to come and appear before the committee because it takes interest in what it sees to be the direction in that regard. So it gets presented to the committee. The committee raises exactly what it raises today, that this may not be enough. So let's try and target those that are in the sector, be it cooperatives and so on, you know, and all these other ones as Dr. Matudu would have mentioned. And then write to them, because maybe they may have not seen this. Secondly, they may have forgotten to make comments. And this is done. And to make responses, which then takes us to 3, of which 2 of them wants to appear before the committee to make their presentations over and above what they've submitted. Like Honorable Mlala raises, the other thing is really not to be seen, to be coercing people to make comments if they feel there's really nothing to comment or nothing major, for example, is a change. Or secondly, they agree with the change that needs to happen to the Postbank. So what is the point? The point is really that you also can't have an endless process of consultation, especially when that consultation has been transparent enough. I think in trying to get a balance, honorable members, it may be that we then agree that we make follow-ups. These would then be circulated to members that these are the organizations that would have been consulted and we didn't get response, so that in your constituencies, you also encourage people to respond to the call. It may be that we give it at least another week or so to get such comments. Otherwise, thereafter, would have to respect those that have heeded the call and responded to the call because they deemed it fit to do so as an interested party to the process. So I think we have to create that balance so that it doesn't look like we do not value those that have adhered to the request made to them. So that's how I would want us to take it forward, create that balance. Take the concerns raised by members now, maybe extend a bit, circulate this information so that if those are within the constituencies we serve, we are able to encourage them to comment. And indeed, if they really don't want to comment, as I say, it would be difficult to ask them to comment. So that's the balanced way forward, honorable members. So I would want you to comment on that so that we move forward on this point and that we can finalize so that the delay is really not on our side and that we can finalize on the matter. Honorable Kola Barnett, your hand is up.
Thank you, Chair. Indeed, yeah, I think an extension, a further extension is warranted, and I'm very happy to personally go to various people I know and entities and ask them for inputs. I just can't see going forward with just one or two. It makes a farce of the whole procedure. I think we do need solid inputs from various entities, and I think we should, as individuals, go out and attempt to get them. Patently, what has been sent out by the staff has not been received with great enthusiasm. So I think approaching heads of various entities by us, I think, is the way to go. So if you'll give us a week or two to do that and see what we can come up with, I think it would make a far more rounded procedure and more acceptable one. Thank you very much.
Any other member?
No, Chair. Thank you.
Yes. Honorable Bambo.
Thank you very much, Chair. No, Chair, I welcome one part of your submission, which is to extend, as the previous speaker has said, because we must not be fixated on process over substance. We really do need as much input as possible for the sake of what we are trying to do. Rather than thinking that we will be undermining those that have submitted, it's not necessarily true. I think even if I was one of those people and the process was extended, I would just understand it to be opening it up to as many ideas as possible. So I think let's think of it in that manner, and let's understand that maybe it might just be the timing that we have possibly asked these institutions to comment. And the idea that we as the committee as well try and find ways in an interesting way, rather than just sending out letters. Maybe we must also try approach them and get as much submissions as possible. You are quite correct, Chair. We can use our constituencies as well to tap into them and then ask for further submissions. We really do need as many ideas as possible, or rather inputs as possible to this which we are busy with. Thank you very much, Chair.
Yes, thank you, Honorable Pambo. Honorable Mlala.
So sorry, Chair. So the proposal is that we need 2 weeks, please.
Yes, Honorable Mlala. So it's just a background sound, so I thought you wanted to come in. But I think there's a sense of agreement, honorable members. We make that extension, we circulate the information. We use also constituency offices, as well as members' constituencies as represented in the committee to try and push the numbers for such comments, and then get back to that. So we would have to do that content advisors immediately after the meeting, so that we can start working on this henceforth. We know that this may then get to a point where Parliament would rise, but we can still get this processed properly as per the way forward we've taken. Agreed? Then we can move to the next item.
Yes, Chairperson. The last item on the agenda is the adoption of one set of minutes, Chair. Thanks.
Honorable members, as you know, we take minutes on a page by page. That's for the 6th of September. Yes, honorable members, that's what is presented as minutes. So those were the items we dealt with, of which some of them are having separate reports in any way. But those are just the minutes. If there are no corrections, can I get a formal mover?
I move, Chair.
Honorable Kolabanat moves. Can I get a seconder?
I second, Chair.
Honorable Chamber seconds. Any dissenting view? Objection? No objection. Agreed to. So the minutes are approved. So that would have been the last point, Honorable Kolabanat. Is that a legacy hand?
No, indeed, it's a new one before you close the meeting, Chair. Just two queries. One is, what is the situation with the subcommittee, and what is our deadline?
I was going to speak to that, Honorable Kolabanat. So I wanted to close the minute.
Okay, yeah. If I can raise also, and then I can be quiet. Could you fill me in? I have spoken with our staff, and it does seem that this committee does no physical oversight. It's a huge concern for me. We should be at the post offices shutting down, the SABC, everywhere. There's so much to look at, and there's so much input that this committee should be getting. I'm not understanding why Parliament seems to be blocking this committee in this regard. So please, could you just fill me in what the situation is and what plans there are to get international input in terms of oversight for one of the myriad issues that are being faced by this committee. Thank you.
Thank you, Honorable Kolabanat. I think let me start with the second point. We have raised that matter as the committee. That sometimes, even if it is within the oversight period to make those applications, but with the changes in the parliamentary program, those would then be declined. So we would have made the request, including from different party caucuses. I can talk about NC Party caucus, that this matter has been raised, and said the programming should really give attention to it. Also because of the number of entities reporting to the committee and the department, we really have to look at going out more to see what's happening there, other than relying only on what comes before us. So you can be assured that's a matter we are giving attention, and that's why even on the MDDA, the way forward we're taking, it's really about the same matter, to say, look, we must still put the application. Surely there will be a reconsideration that the committee is also given space to do that oversight. So it is not the making of the committee necessarily that it chose not to, but we have evidence to show that proper applications would have been made, but out of circumstances would be declined. That was the second point. I think as it relates to the subcommittee, we're making the application to move. Remember, there was a discussion there that the 26th was, I think, erroneous been put, because that's a Monday when most parties are doing constituency work, but there's also traveling time for members who attend physically to Parliament most of the time. So we'll rather use the slot we have, which is the Tuesday, the 27th. So that application is being sent to the House to just change the date to the slot. So it's meant to be on the 27th. We do both the subcommittee deliberations on the SABC board and the committee to receive the subcommittee report, so that post that meeting of the committee, once there's adoption, we immediately send that to Parliament's NA table so that the programming could consider what we have raised, that we would want to have this approved by the served before the House, so as not to have interim arrangements post the 15th October. However, Honourable Member, it's important to also raise this point, which is something maybe the content advisors or the community support staff may want to also brief us on, is that there were letters received which were circulated to yourselves from different organizations against certain candidates, which letters were also used in the interaction with such candidates in the questions that would have been asked. But we wanted legal opinion on some of, on all of them necessarily, so that we know that at the time of deliberations, we must have that cleared. There were situations where also even candidates would have indicated that there would be letters or information to prove certain points that they have raised in clearing their names for members to be able to go through that. And there have been such that has been received, I think some of them by yesterday by committee support staff. But the legal part has not been received unless received today. All that info, the approach is to give members up front so that when we get to the actual deliberations, we deliberate from an informed position, so that we do not prejudice any candidate on the basis of allegations or anything that could not be proven, but also at the same time that from what we seek to build in the country, we do not put candidates who may have questionable things over them that there's evidence on. So it's to create that balance for the deliberations. So we're targeting the 27th for both subcommittee and the committee. We will get an indication surely by end of today or in the morning on whether that approval has been given, but also if the information is available, get circulated so that members have an opportunity to go through it well on time. I hope that answers you, Honorable Kolabanat, and all members, as I was to clarify this anyway for all members. Thank you. That having been said, honorable members, Ajra, I take it that was the minutes was the last item, and therefore it will be proper to thank members once again for contributions. We are together in this, and we should really ensure that the committee is effective in its oversight work. So all suggestions, we usually consider them as a way of improving this work that we do collectively as representatives of the people. With that, the meeting stays adjourned until we meet again. Honorable members, thank you.